Let's focus on how to protect our legacy. While life insurance dovetails with this topic, the primary way to protect your legacy in a financial sense is through estate planning. As you may know, probate is the legal process for settling your estate. And even if you have a will, it can be slow and costly, and it's public. And some states are worse than others. In Colorado, where I live, it's not too bad. But where Britta lives in California, the process is quite onerous. But with no plan at all, probate can be a true nightmare for your loved ones. If you die without a will, the court will decide who inherits your assets, as dictated by your state's laws on intestate succession, which generally hinge on whether you are married and have children, with your spouse and your kids getting priority, followed by other close family members. The calculation, it's formulaic, it's simplistic, and treats individuals in the same category exactly the same way. But you can avoid this by having an estate plan, which will ensure that your assets go to the beneficiaries of your choice in the amounts that you want and in the manner that makes the most sense. So, for instance, in trust for a child who's a spendthrift rather than outright. Similarly, if you become incapacitated and have no plan in place, your family would have to petition the court to appoint a guardian or conservator to manage your affairs. Another very costly and time-consuming process that is often traumatic for everyone involved and can result in conflict between your loved ones over your finances and your medical care. On the flip side, an estate plan can help ensure that your values and goals are met. At a high level, an estate plan will involve drafting several key documents, including a will, which sets out your intentions of how to distribute your assets and appoints an executor to manage the process. May involve a trust, revocable and irrevocable, which is a specific financial instrument that can be used to transfer and manage assets and is administered by a trustee. A durable financial power of attorney that allows you to appoint somebody to handle the finances if you become incapacitated. And similarly, a healthcare power of attorney, which lets you appoint someone to handle your medical care if you become incapacitated. And this doesn't have to be the same person. The right person to handle your finances might not be the right person to handle medical decisions. So, for example, in my family, it's probably no surprise that I am the financial power of attorney for my parents, but my physician sister is the medical power of attorney. A final key document is an advance directive, also known as a living will, which provides physician direction on end-of-life decisions. Allows your family not to have to make these decisions during a very difficult time. And as part of this whole process, if you have minor children, it's very important that you set up guardianship designation. So who are those people that will raise your kids if something were to happen to you? And your plan is also going to have beneficiary designations for some of your assets so they can transfer directly without going through probate. Your documents are going to be unique to your situation, and some people's situations and documents are going to be more complex than others, but there are a few things generally to consider. First, estate law is very state tax specific. So if you move states, make sure to get your documents updated and make sure you understand the differences in the rates and rules between the two states. Second, while state laws may vary, in general, inherited monies, as long as they are not commingled in a joint account, remain separate property and not a marital asset that is subject to split in the case of a divorce.